privileged to be able to close out this week, and what I've been asked to do is to share with you some of the important legal decisions that have affected civil rights. As we look at the civil rights era, the civil rights movement, it is probably my favorite thing to study in American history. Obviously, because it is ripe with rich landmark judicial decisions, but also I think it's a little bit more personal because I am from Alabama, where a lot of this stuff took place. I grew up studying and learning about this. I went to college and law school in Montgomery, Alabama. My wife grew up in Montgomery. So we've had the opportunity to visit, spend time at a lot of these landmarks and other places where these things have happened. We've had the opportunity to talk to people who live these things. Some of them you read about in history books, some of them you'll never know about. Which brings me to something very important that I want you to take from today if you don't listen to any of the cases that I tell you. Talk to people. Talk to your parents, talk to your grandparents, talk to their friends, talk to your teachers. Because I bet you will find it not so hard to find somebody that didn't read about history in a textbook, they lived history. Sometimes in some of the strangest places you run into these people. I remember being in line at a cafeteria-style restaurant and having an encounter with a woman telling me about her living through history and some of her interactions with Dr. King. Earlier this week, Tim Lewis mentioned that he just found out he was not that far from where Dr. King was shot when he was shot. Monday night, Christy and I were reminded of this. One of our dear friends and mentors saw that Christy had spoken earlier this week and sent her a message. It said, hey, in case you didn't know, my father-in-law in the early years of the civil rights movement diffused a bomb on Dr. King's front porch here in Montgomery and then was invited inside to have coffee. And we're thinking, what? And Christy's known this couple for most of her life. I've known them for about 15 years. And like, wait a minute, you're just telling us this? Now, I will admit that I apparently knew about that and never told Christy. Her father-in-law, Van Pruitt Jr., was a leader in forensics in the state of Alabama. And when I was practicing law there in Huntsville, they built a new crime lab and they named it in his honor. And I was looking up this morning just to see some facts about that. And I ran across the article from the dedication, and there was a blurb in there. And I remember reading that article like 12 years ago, so my apologies. But you'll be surprised in what you find, and that makes it more real. Well, let's get to some of these cases. Some of them you'll be familiar with, some of them may be new to you. Dred Scott v. Sanford, decided in 1857. Dred Scott was a slave in Missouri. He sued for his freedom on the grounds that he had lived in a time for a, quote, free territory. The Supreme Court ruled against him. The Supreme Court said that under the Constitution, Dred Scott was his master's property. At the same time, the court also ruled that the Missouri Compromise, under which Missouri was admitted to the Union as a slave state, Maine as a free state, and slavery prohibited in the territory that later became Kansas and Nebraska, was unconstitutional because it deprived slave owners of their property. 1896, a case that you probably all have heard of and are somewhat familiar with, Plessy v. Ferguson. Let's have a little interaction like Professor McNeese did yesterday. What did Plessy v. Ferguson do? What did it say? Separate but equal. Plessy was 1/8 black, which under Louisiana state law, he was considered a black man. And because of such, he could not go where the white people could. And Louisiana had a law at the time requiring restaurants, hotels, hospitals, and other public places to serve African Americans in separate but ostensibly equal accommodations. Plessy sits in the whites-only car of the train. Subsequently, he informs them that under the law he is black, he's arrested, and he's convicted. And as you're aware, it establishes a separate but equal doctrine. The court said that segregation is, quote, universally recognized as within the competency of the states in the exercise of their police powers. Basically what they said is it was a states' rights issue. It was up to the individual states to decide that particular issue. What is of interest, particular interest in that case is there was one dissenting opinion written by Justice John Marshall Harlan, who himself was a former slave owner. And in his dissent, he had these words, saying that the ruling would, quote, stimulate aggressions, more or less brutal, upon the admitted rights of colored citizens. 1938, Missouri ex rel. Gaines v. Canada. The Supreme Court ruled that Missouri could not satisfy its obligations to provide equal protection by sending African American residents to an out-of-state law school, that Lionel Gaines must thus be admitted to the all-white University of Missouri School of Law. This case is also important because it was the beginning of the NAACP's Legal Defense Fund's effort to chip away at the separate but equal doctrine. 1950, we have the cases of Sweat v. Painter and McLaurin v. Oklahoma State Regents. Here, the court struck down segregation of African American students in law and graduate schools. The Justice Department, in its brief to the court, said that it believed Plessy was unconstitutional and should be overturned. The NAACP Legal Defense Fund lawyers, led by Thurgood Marshall, began to devise a strategy that would force the court to re-examine the constitutionality of separate but equal. 4 years later, we get to the case that you may also be familiar with, Brown v. Board of Education. The Brown case, as it was heard before the Supreme Court, actually combined 5 cases from 4 different states as well as the District of Columbia. The named plaintiff, Brown, Oliver Brown, his daughter, Linda, was a 3rd grader, and she had to walk 6 blocks to the bus stop to ride the bus to her school, which was a mile away, when the all-white school was 7 blocks from her home. Later on in her life, she recounts in some interviews that she really didn't understand it, and she just wanted to go to school with her friends. She lived in an integrated neighborhood, and she didn't understand those type things. What is most interesting to me about the Brown case is they were not arguing that there were any inequalities in the facilities or the level of education. What they were arguing was that separate but equal is inherently wrong. And as we know, the Supreme Court agreed with that. Chief Justice Earl Warren, reading his first major opinion from the bench, said, "We conclude unanimously that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal." A year later, 1955, we have a case that we normally just refer to as Brown 2. Brown 2 said the Supreme Court held that school systems must abolish their racially dual systems with all deliberate speed. 1956. The Supreme Court, without comment, affirmed a lower court ruling declaring segregation of the Montgomery bus system illegal, giving a major victory to Rosa Parks, Martin Luther King Jr., and thousands of anonymous African Americans who sustained the bus boycott in the face of violence and intimidation. One thing that I failed to mention, and I probably should, the lead lawyer for the NAACP in the Brown cases and several of the other cases before the Supreme Court was Thurgood Marshall. What do you know about Thurgood Marshall?
First black Supreme Court justice.
He becomes, later on, the first black Supreme Court justice. 1958, the Supreme Court upheld the rule of law in Cooper v. Aaron, stating official resistance and community violence could not justify delays in implementing desegregation efforts. 1968, Jones v. Alfred H. Mayer Company. The court upheld that the Civil Rights Act of 1866 bans racial discrimination in housing by private as well as by governmental housing providers. 1971, Swan v. Charlotte Mecklenburg Board of Education. The court ruled busing was an appropriate legal tool for addressing illegal segregation of the schools. Also in 1971, Griggs v. Duke Power Company. The Supreme Court ruled that Title VII of the 1964 Civil Rights Act prohibits not only intentional job discrimination, but also employer practices that have a discriminatory effect on minorities and women. The court held that tests and other employment practices that disproportionately screened out African American applicants for jobs at the Duke Power Company were prohibited when the test was shown not to be job-related. 1978, Regents of University of California v. Bake. Supreme Court ruled that the medical school's special admission program setting aside a fixed number of seats for minorities violated Title VI of the 1964 Civil Rights Act. At the same time, however, in an opinion written by Justice Powell, it ruled that race could lawfully be considered as one of several factors in making admissions decisions. In his opinion, Justice Powell noted that lawful affirmative action programs may be based on other reasons than redressing past discrimination. In particular, a university's educational interest in attaining a diverse student body could justify appropriate affirmative action programs. These are just a few of the significant court cases that have had an impact on the civil rights movement, on our rights as all of us who are Americans, and progressed us to where we are today. If you have any interest in knowing more about these cases, I didn't give you much detail, basically just what the rulings were. If you're interested in knowing more about these particular cases or other cases that have affected civil rights legislation, feel free to email me, tweet me at YCCJ, stop by and see me, and I'll be more than happy to point you in the right direction. Thank you for your time.